by Fredrick Obura, published September 30, 2017 at 15:17, updated September 30, 2017 at 16:09 GMT. 3 Supreme Court Judge Njoki Ndungu Mboya says Supreme Court Judge Njoki Ndungu engaged in acts that were in complete disregard of the principles of due discharge. Petitioner claims the judge omitted and ignored to exhibit the value of integrity. 4 judges nullified Uhuru's win in August 8 presidential election. 2 judges including Njoki dissented. Nairobi, Kenya. Nairobi-based advocate and former Law Society of Kenya Chief Executive Officer Apollo Mboya has filed a petition seeking to remove Supreme Court Judge Njoki Ndungu from office. In a petition addressed to the Judicial Service Commission (JSC), Mboya questions Njoki's professional competence and integrity among other issues during the case of Raila Odinga versus IEBC, and 2 others in regards to the August 8 general election. Also read: Muluka Chiloba must quit, he cannot ignore hue and cry against him. Raila Odinga filed a petition in Supreme Court challenging the outcome of presidential results in which Independent Electoral and Boundaries Commission (IEBC) declared President Uhuru Kenyatta winner. The court, however, overturned the win, citing malpractices. 4 judges including Chief Justice David Maraga agreed with the nullification of Uhuru's win, while 2 Njoki Ndungu and Jack Dinajwang dissented. The 2 judges in their verdict, read separately, found that National Super Alliance NASA leader Raila Odinga failed to prove that the results announced at the constituencies had issues. In a petition referenced compounded misconduct against Njoki. Ndungu Mboya, a former Law Society of Kenya boss, argues that Njoki exhibited total lack of courtesy and civility towards her fellow colleagues on the bench of Supreme Court, while delivering reasons as to why she disagreed with the nullification of Uhuru's win. According to the petitioner, the judge lacks judicial temperament, exhibited lack of professional competence, and engaged in acts that were in complete disregard of the principles of due discharge of the judicial office. He says that particular elements of misconduct exhibited by Njoki is that in paragraph 662 of her dissenting judgment, she states that the court, however, had no option to personally examine the original forms deposited in the registry. The majority did not do so, and proceeds in paragraph 669 to state that in the interest of justice she examined each forms that had been disputed. Mboya says that, if the assertion is true, then Njoki ought and must have examined each of the disputed forms on 28 and 29 August 2017, before she delivered her dissenting judgment on September 1, which she amplified in her detailed dissenting judgment on September 20. He further says that Njoki in her summary dissent judgment did not allude to the fact that she examined and verified each of the disputed forms, if at all, before arriving at the decision to dissent. Also read: Jubilee's reaction to annulment of poll makes no sense. Njoki dishonestly ignored the forms tendered by IEBC for scrutiny, and based her judgment on forms and materials not tendered for scrutiny, he argues, noting that it was not humanly possible that the judge examined all the disputed forms from the date of hearing August 28 to the date of summary judgment of September 1. Mboya also says that the judge exhibited total lack of courtesy and civility towards colleagues on the bench.